Welcome to Illinois Law, sponsored by the Illinois Bar Association. My name is Sam Kavathas, and I'll be your host for tonight's show. We have a great topic tonight on mortgage foreclosures, and this show will be on the early stages of litigation. And I have three fine guests to help us with tonight's discussion. My first guest is the Honorable Margaret Brennan. Judge Brennan has served as a judge in the Circuit Court of Cook County since her induction to the bench in December of 2002. As a judge, she has served in the 1st Municipal District, 5th Municipal District, and is presently assigned to the Chancery Division Mortgage Foreclosure Mechanic Lien Section. Prior to sitting on the bench, she practiced law for 15 years, working for the City of Chicago, Commonwealth Edison, and Exelon Corporation. She is a graduate of the University of Illinois and obtained her Juris Doctor from Illinois IIT Chicago-Kent College of Law. Judge, welcome to tonight's show.
Good evening.
My second guest is Steve Bashaw. Steve is a principal of Steve B. Bashaw PC with offices in Lisle, Illinois, and concentrating his practice in real estate litigation, mortgage foreclosure, having represented financial institutions and defending debtors alike. Steve is the past chair of the Illinois State Bar Association Real Estate Section Council, chair of the Case Law Subcommittee, a member of the Illinois State Bar Association Assembly, and a director of the Illinois Real Estate Lawyers Association. He is a frequent continuing legal education speaker on case law updates, mortgage foreclosure, and real estate law for the Illinois Institute of Continuing Legal Education, the Illinois State Bar Association, the Chicago Bar Association, and the other bar associations around the Chicago area. Steve is the author of the articles, and he's contributed to the Illinois Mortgage Foreclosure Practice Handbook with the nuts and bolts of foreclosure and mortgages in distress, representing defendants in foreclosures. In 2009, Steve was honored with the recipient of the Edward J. Lewis II Pro Bono Service Award from the Chicago Bar Foundation and Chicago Bar Association in recognition of his working in assisting and training volunteer lawyers in mortgage foreclosures. Steve, welcome to tonight's show.
Thank you.
And my third guest is Mitch Lieberman, and he is a partner in the law firm of Noonan and Lieberman Limited in Chicago, Illinois. He has been admitted to the practice in Illinois since 1986 and has concentrated his practice in commercial and residential mortgage foreclosures, real estate and mortgage litigation, creditors' rights in bankruptcy, and civil and appellate practice. He received his BA from the University of Illinois and his Juris Doctor from DePaul University. In addition, throughout his years of practice, he has been appointed by Cook County judges to represent their court-appointed receivers regarding commercial foreclosures, including condominium projects, high-rises, and multi-unit offices. He is a co-author of the Illinois Mortgage Practice, Illinois ICL 2003, and author of the Real Estate Litigation Practice ICL in 2008. He is also a faculty member of the Illinois Business Institute and Lorman Educational Services, and currently he is a member of the Chancery Division Mortgage Foreclosure Case Management Advisory Committee and has been appointed the chair of the Cook County Commercial Foreclosure Committee. So we have some great guests for tonight's topic. I'd like to start out first by asking you, when we talk about mortgage foreclosures, Mitch, what is it? When do you become a mortgage foreclosure?
Well, Sam, good evening. I think it's important to start out of what a mortgage is. And what a mortgage is an agreement between parties, a borrower and a lender, to use real estate to secure a note for repayment. And what happens in the mortgage foreclosure process is when the note becomes in default, which is a non-payment of the monthly mortgage payments, a lender will attempt to either work it out, contact the borrower, and if that doesn't work, they have no other option other than to file a mortgage foreclosure complaint.
Now, typically, let me ask you this, you know, when you say one payment's late, I mean, people are late sometimes with a payment or two. I mean, does it actually start, or do the banks usually start it, or the people who are the lenders start it after a first one, or is usually a little time period?
There's a time period.
Yeah.
I think the first payment is by definition a default, but very rarely does a lender move on a first payment default. Normally what happens is it would be multiple payments, 3 or 4. When a borrower is in default, prior to filing any foreclosure action, a lender will send out a notice to the borrower.
Is this required, or is it done automatically, or what happens?
In Illinois, in Cook County, it is required. It is what's called a grace notice. Basically, it tells the borrower that they're in default. It gives a list of state agencies of who they can contact.
And these state agencies, what are they there for?
Well, they're there to help the borrower,
Okay.
to counsel the borrower. They have 30 days to contact these state agencies. If they do, then they get an additional time. If they fail to contact these state agencies, a lender will file a mortgage foreclosure.
Now, how does the mortgage company know that they've contacted this agency? What type of, do they get a letter or something, or what do they get?
The borrower has to reply and indicate that they have made contact.
And that's good enough, just a reply saying I've contacted somebody?
Usually, yes.
All right.
A lender will then stay any proceedings for 30 days. Also, there's another notice that has to go out, which is an acceleration notice. And that basically tells the borrower exactly how much they owe, and it gives them a time period to reinstate the mortgage. Reinstate is a definition under the Illinois mortgage foreclosure law. Basically, it's an amount to cure what they owe. Usually it's the monthly payments.
Okay, and that is a lump sum amount that you have to come up with for that? Is that what you have to do?
Sometimes, Sam, I talk to people who find that acceleration letter confusing. Because, of course, what's happening is that, that Mitch is sending them a letter that says you owe $250,000. And most lay people don't know the difference between reinstatement, in other words, coming up with the back 3 payments, and the acceleration. Now the whole principal balance is due. And I get calls from, and I'm sure you do too, from people who say, well, do I have to pay you $256,322? Right?
I assume on the letter it probably spells out what you owe to reinstate, or is there a specific thing, or not necessarily?
Yeah.
Well, that's a question. And there are certain laws, federal laws, that a lender must abide by. And I think Steve brings up a very good point. There are differences in the mortgage foreclosure process. Reinstatement means to cure the amount that's due and owing. And most likely, a borrower will contact a lender and try to discuss it with them. Although nowadays that's very difficult. There's a lot of layers with lenders today.
But usually if you do pay off the amount of the past due, that will take care of the problem if you pay up what's owed.
Yes.
Okay. So from the time period of when you first start, let's say 3 months behind, going through all this initial process we talk about to getting that final letter, how much of a period of time is that, generally speaking, a general time frame?
Well, normally from the date of the first payment default through the letters, it could be 3 or 4 or 5 months.
So a person may have a little time to kind of talk to relatives, whatever it might be, to at least get that money. It's just they're not going to get a letter and saying you're out of your house, right?
That's correct.
Okay. Now, when they do get that letter, Steve, what's a good idea for somebody to do when they get that letter?
Well, I think it's awfully important for people to take a look. And it's so hard because people just don't want to confront this. They get into denial, right? But it's important for them to take a look and see a couple of things. Number one, do they have equity in their house? And equity, of course, is value. In today's market, that's sort of hard to figure, but value over and above the debt. If you don't have equity in your home, then some of your alternatives aren't available, like reinstating your mortgage or refinancing the mortgage. Perhaps selling it is going to be difficult. The second thing that I always think that people should do after they've determined the issue of equity is to look at what I frame as utility. In other words, what does it cost every month to make the mortgage payment, real estate taxes, insurance, homeowners association? And is that some reasonable rent for the property? I have people who come in to see me all the time. The property has no equity, it's 30% less, and they're paying $3,000 a month for property they could rent the equivalent of for $2,000. There was a time 10 years ago when people would say, well, it cost me $100 extra a month more than what it's worth, but I'm, quote, building equity. But those days are gone. In today's economy, we're not building equity. So I think you need to do those two things first. Determine equity and utility so that you can see clearly and somewhat objectively where you're going.
Now, you know, another thing that you see is, you see a lot of these ads that out there, people, you know, and I don't want to say scam artists, but people who try and take advantage of the situation. They say, we can help you out, we can save your house, we can do all these things. What do you tell a consumer about those type of companies that are out there advertising or whatever it is they should be aware of? You know,
I think the first thing, when we see them in court, it's after a case has already been filed, but one area we want people to look at is to go to HUD certified counselors. Those are free programs where the individuals will be able to sit down with a counselor that can help do the analysis of equity in the property and whether or not explore various options on how they can resolve the financial aspect of this foreclosure suit.
And a HUD certified counselor is going to charge you what?
Nothing. It's
not
free.
going to charge you something with a comma in it. That's the thing that I see that differentiates it so many times, is that these less than legitimate loan modifiers, counselors, not certified, they want you to pay them something with a comma in it, and then you ask them what they're doing and they really can't tell you.
You know, we're going to take a short break and then we're going to get back to this topic about the scammer. This is Illinois Law, sponsored by the Illinois Bar Association. We'll be back in just a minute with our show on mortgage foreclosures, the early stages.
Bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over.
Time I come home! It's our problem! Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest...
Generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Hello, welcome back to Illinois Law, sponsored by the Illinois Bar Association. I'm Sam Kavathas and I'm your host, and we're talking about mortgage foreclosures, the early stages. And my guests are the Honorable Judge Margaret Ann Brennan, Steve Bashaw, and Mitch Lieberman. And we were discussing the, I don't want to say scam artists, but you know, companies that advertise that they can save your house or whatever it is. Realistically, nobody can save your houses from this process, correct? Unless you follow the procedures that need to be done, like repaying the mortgages.
I think it's very difficult.
Yeah.
And I think it's important, as Steve was talking about earlier, that a borrower obviously receives these notices. They're upset, and they may contact these individuals or companies. And I think the first thing to look at is the charges that are given. Many times I've appeared in court and the borrower will say, I paid $3,000 for help. Well, I think something that they should look at as a borrower in Cook County is, will this person come to court? Will this person help them out? And usually that answer is no.
So they're better off, if they need some representation and they can afford it, to find an attorney who practices in the area?
Correct.
And are there areas where you can go find an attorney who practices in the area?
Well, sure, and not only that, But the Circuit Court of Cook County has a help desk on the 13th floor. Every judge will direct you there.
And we'll get to that in just a minute on the...
There's, you know, there's all these places to go. But Sam, you know, you're right, because people do come to attorneys as well as other people, and they say, well, do you know the trick about the radar, right? And you have to say, no. You know, I'm not a magician, I'm a lawyer. I can get you due process. We can make sure, you know, that we have the proper accounting, but we don't make money appear and disappear. We have to resolve the problem.
Let's get into the actual process. Judge, they get to court. What can a litigant expect when they have to come to court for the first time?
First time most litigants appear before me is at a case management conference, and that would be set by the computer 60 days following the date that the plaintiff would have filed the lawsuit. So it's early enough in the proceedings that they can get information and start responding, and I really encourage people to try and come to court, because you have to be part of the process to try and get a resolution. Ignoring it's not going to help.
How would a litigant know where to go or what they're supposed to do? You say if 60 days after a lawsuit's filed, what do they get to let them know?
If they have already filed their appearance in a formal response to being served with summons, they will get a postcard from the clerk of the circuit court. Otherwise, the plaintiff's firms will mail out to the address of the mortgagor notice that this case management conference is happening on the specific date.
So if somebody's been properly served and they don't file an appearance, so they're not getting the postcard, then they are notified a second way, maybe by the attorney handling the lawsuit.
Yes, and I think that's a change. I think what everyone has to understand, on mortgage foreclosure, it's a fluid operation. I think Cook County has done a very good job of trying to protect the borrower and the consumer. So there's certain burdens that the plaintiff is given. Not only the service of summons, the summons has changed. There's much more information on the summons. It is bilingual, it's in English and Spanish, and it also gives them certain places where they can go for help. Okay. I think automatically, as the judge had indicated, there's a 60-day date given, but the plaintiff also has a burden to give out notice. Even if they don't have service, you do send it to the last known address.
And then when they do come to court, what happens then?
When they come to court at that time, either from the summons, they would have been able to see the helpline number. It's a 1-877 number that they can contact.
Who sponsors the helpline?
That is actually through the Cook County Mortgage Foreclosure Mediation Program. So that hotline will then guide them towards a housing counselor that they can meet with to discuss possible solutions, and then the housing counselor will help them evaluate whether or not mediation would be appropriate to bring the borrower and the bank together to try and see if a modification would work in their
And what
benefit.
if they haven't done that? I know you mentioned, we talked about it, you started to talk about it, that the help desks there in court, where are those located? How will the people find it? And is that something that they're available to? Who tells them about this?
Well, if they're before me, I will tell them that there are volunteer attorneys out on the 28th floor that they can speak to get information about the program. And also, they can go to the 13th floor where there's also a help desk.
And who are these people that are helping them?
They're volunteer attorneys with Chicago Volunteer Legal Services. And then the housing counselors are HUD certified housing counselors that they're going to work with to really make the analysis and help people do the analysis that Steve spoke about.
And how much does it cost for them to do this?
It's a free program. It's available to homeowners in Cook County. You actually have to be a resident of Cook County and also residing in the property. It's not available for investment property at this time.
And what actually do they help you do? What is it that process out there helps you do?
Well, the first thing that they do is they go through that same analysis, Sam, that we talked about before, about determining if there's equity in this house and determining what your capabilities are and whether this is a good thing to do and whether you qualify. And you know, just getting educated and being part of this process is just so important, because people are not victims once they're involved. Once they're involved, they're part of it, and they see what's available to them.
How many people take advantage of this mediation, these hotlines, these helplines? I mean, who does this? What's the percentage of people doing this stuff?
Right now we have 1,400 mortgagors are in process of mediation. 340 have completed a mediation process. but more than 18,000 individuals have received free legal advice through the mediation program, and more than 7,000 have spoken with housing counselors.
So when we say mediation, what are we talking about happens once they sign up for this mediation? What is mediation?
Well, we go off-site. In fact, it's across the street at the Cook County Administration Building. I've done a couple of those mediations. And you know, I guess anecdotally, I can tell you about one that was very successful. The people qualified for mediation, but they didn't know it, and they couldn't communicate it because they had a profound language issue. And so we got them into the system, got them somebody who could speak the language that they spoke, helped them fill out the forms which they didn't understand, because everything is so form driven. And suddenly it became very clear that they did qualify and that they could get a modification.
And who goes to these mediation? I mean, is there just the people there, or the lenders there, the representatives? Is there somebody listening to this process? Is there a mediator there?
Well, Sam, I think one of the benefits to the program is communication and connecting the parties. I think once they get past the first stage, which is some counseling, and I think there's some qualification of financials and things of that nature, and when it gets to the mediation process, a lender has to be available. Usually by phone, but there has to be a connection. And that's, I think, important if there's going to be success.
What does that mean, a connection?
Well, a connection between the lender and the borrower.
Okay.
By the time mediation occurs, the lender will have certain financial information that's required of the borrower prior to mediation. So they'll be able to make good, informed decisions. And the mediator will be there to try to put the parties together and see if they can find a happy medium. And
one thing I want to ask you, we were talking about that. Now, when you fill out these forms and everything, you know, you want to look good so that you can get your more. I mean, is it something that you would want to, when you fill this out, what would you recommend, or what do you tell the clients or people that are filling out these forms?
You know, Sam, I have people say, so they say, well, should I look better or should I look worse? What should I look? And I always tell them, do exactly the truth, because what's going to happen is there's going to be a representative from the plaintiff, and it's usually somebody with it's always somebody with decision authority. It's not just a clerk who's going to have looked at those forms, compared those forms to the credit report, and they're going to see if everything fits and matches. So it's very important that you just put it out there the way it is. Don't try to dress it up. Don't try to dress it down. But that's hard for people when their life is challenged because they've lost a job or something, you know.
We have a couple minutes left. I'd like to kind of wind up the process for this mediation. You said they go there and they talk with the mediator, and the bank's there, and the person who's the debtor's there, and they work out a deal, right? They'll say they work out a deal. Is it in writing? And then what happens with that?
Well, yeah, and I can speak to it. I think it's important that everyone understands the landscape and the framework. What you're attempting to do is, as Steve had indicated, the borrower has to give true financial information because he's going to be making payments in the future. It is a written loan modification. The terms, of course,
is that what
are
they call it, a
negotiable.
loan modification?
Right.
With
Yes.
what happens?
Yes. Sometimes the interest rate is lowered. Sometimes the amount that is due and owing, the arrears, is put at the back end of the loan. Sometimes the loan is extended from 30 to 40 years.
So there's a lot of flexibility in working this out, correct? I mean, meaning procedure-wise, they can do different things to get where they want to get.
I believe so, yes.
Okay. And in the last minute, Judge, what happens when they reach an agreement with this mediation? What do they do? What happens with the case?
The case does come back to court because some cases will be resolved, and we've had a lot of success. Some do not get resolved through mediation. So we need to allow the process to continue on. So after approximately 12 weeks from when it first came to be assigned to mediation, it will get back to an intake day again post-mediation. And if it's been resolved, the case will be dismissed out at that point. If it has not been resolved, it will be reassigned to the trial call to go through the remainder of the foreclosure process.
Okay, well, listen, thanks very much. There's a lot to talk about on this topic. I'd like to thank my guests, the Honorable Judge Brennan, Steve Bashaw, and Mitch Lieberman, for being with us on the Illinois Law Show, sponsored by the Illinois State Bar Association. Thanks very much, and thanks for watching tonight's show. And